I now have the great pleasure to introduce today's guest of honors and keynote speaker, Judge President Trendafilova, President of the Kosovo Specialist Chambers. Judge Trendafilova, a nationality of Bulgaria, is a real veteran of international criminal law. From 2006 to 2015, she was a judge of the ICC, serving in the pre-trial division, but also sitting on the first two final appeals of the court. As such, Judge Trendafilova made vast contributions to the ICC's work during a critical period for the court's growth. Since 2017, Judge Trendafilova has been the first president of the Kosovo Specialist Chambers, leading that institution's development from its early stages. We are truly privileged to have the opportunity to hear President Trendafilova's reflections on current issues in international criminal law. President Trendafilova, you have the floor.
Dear Judge Fernandez, President of the Assembly of States Parties, Vice President of the Assembly of State Parties, dear President Hofmansky, dear Vice President Ibanez and Honorable Judge Perandi-Bruchambeau, dear fellow judges, Mr. Prosecutor, Madam President of the ICC Bar Association, Mr. Registrar, Excellencies, and dear musicians. I enjoyed very much your music. Thank you. I really would like to start with words of thankfulness to the President of the International Criminal Court, Judge Hofmansky, who kindly invited me to mark the official opening of the judicial year. I feel honored by this invitation. It is also emotional to be here today at the seat of the ICC, where I was privileged to spend 9-year term of office as one of the first judges elected to the World Criminal Court. The ICC will always feel like home to me, and I remain passionately committed to its mandate and success. Well, the pandemic, unfortunately, continues to impede us from gathering in person. Our shared commitment to the field of justice and to the rule of law has not prevented us from working and meeting virtually as we do now. It is very important, as was already underlined, to solemnly and proudly mark the start of the new judicial year and to send the message that courts and tribunals stand firmly by their duty to ensure independence, impartiality, and fairness in the discharge of their mandate, regardless of the challenges facing them. Justice carries on even in direst of circumstances if we, those with our shoulders at the wheel, keep pushing forward. It is especially poignant to be able to open the judicial year here in The Hague, the city which hosts an impressive number of judicial and other international institutions. It has become known as the city of peace and justice and the legal capital of the world. It is the city where the famous Hugo Grotius and Baruch Spinoza resided, where the first peace conference took place in 1899, leading to the creation of the Permanent Court of Arbitration, which in turn led to the building of the beautiful Peace Palace, the home of the International Court of Justice today. The past year has been marked by important developments for international justice that must be noted. As President Hofmansky just said, the ICC made significant progress with seminal appeal and trial judgments, pre-trial decisions, related to confirmation of charges, authorizing oath investigations, reparation order as well. Last year, the ICC was also busy advancing the judicial activities for this year, 2022. As emphasized by the President, we will witness this year an unprecedented level of trial activity in the court's history. In addition, the ICC was committed to analyze criticism addressed to it, and most importantly, contemplated best approaches to respond thereto. Last year, Mr. Karim Khan, the newly elected ICC prosecutor, assumed his duties ambitiously towards the contribution of his office to international justice. I should also recall some other developments beyond the ICC, starting with closing the case against Ratko Mladic with a seminal appeals judgment, and also 2 trial judgments issued by the successor institution to the Rwanda and Yugoslavia tribunals. At my own court, the Kosovo Specialist Chambers, 1 new accused was arrested last year, bringing the total number of accused to 8, and 2 cases already proceeded to trial. Regrettably, the Special Tribunal for Lebanon faced unprecedented financial hurdles and was forced to shut down the majority of its activities in record time, leaving only the appeals chamber to render its judgment. This is a cautionary tale for us all, of which we all should stand ready to learn. The road to the establishment of these courts, with their successes and tribulations, has been a remarkable one. The need to respond to atrocities that deeply shock the conscience of humanity galvanized the foundation of international and internationalized courts and tribunals. Indeed, their creation and mandate outside the traditional structures of states is probably one of the most significant changes in international law in the past century. We are no longer at a time when we question whether individuals who committed crimes of concern to mankind will be brought to account. The existence of these courts further results in a comprehensive record of such grave crimes through the testimony of countless witnesses and other evidence presented, and ensures that these heinous acts do not fade away unnoticed. The momentous development in the field of international justice was the adoption of the Rome Statute of the Permanent International Criminal Court in 1998, 17 July. The road to the ICC becoming operational, which required at least 60 ratification of its statute, was not without very real challenges and took place against the backdrop of events that would forever be seared in the memory of humanity. In September 2001, the Twin Towers fell. The smell of sulfur remained in New York's air. Smoke plumed from ground zero. Yet, the world convened to keep building this court. The United Nations continued hosting the work of the Preparatory Commission for the ICC. The next spring, the 60th ratification was deposited. The international community sent the unequivocal message that justice will neither be delayed nor stopped, no matter how difficult the circumstances. The ICC, however, is not alone in the arena of international justice. One has only to think about the ICTY and ICTR with a combined 254 indicted individuals. We have also seen the proliferation of other international, hybrid, and regional courts to address accountability for conflicts that either occurred before the temporal or fall outside the subject matter jurisdiction of the ICC, or are established to deal with specific circumstances on a smaller scale. To name a few, the Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, the Extraordinary African Chambers in Senegal, the Kosovo Specialist Chambers. I'm sorry, I'm not exhaustive. We should also recall mechanisms created to assist in the prosecution of individuals having committed widespread atrocities, like the International, Impartial, and Independent Mechanism for Syria and Myanmar, the United Nations Investigative Team to promote accountability for crimes committed by Daesh, as well as more localized national initiatives, including the war crimes offices established throughout the former Yugoslavia. We should also not leave unnoticed the determination of national authorities on the basis of universal jurisdiction to prosecute and put on trial individuals for international crimes they allegedly committed. Some states such as Sweden, Norway, France, the Netherlands, Germany, Belgium, Finland, I'm still not exhaustive, had been active in conducting investigations and prosecution on the basis of universal jurisdiction. Just last week, a German court sentenced a Syrian colonel to life imprisonment for crimes against humanity in a landmark case based on universal jurisdiction. In this regard, it should be recalled that the increase in prosecution of international crimes before national courts reflects the very sense of the principle of complementarity, which is the cornerstone of the Rome Statute. The ICC encourages and assists domestic institutions in carrying out investigations and prosecutions for serious international crimes through their independent, impartial, and fair national proceedings. Each of these international, regional, and hybrid judicial institutions, as well as domestic authorities, have enhanced and further shaped the course of international justice. International justice, as it stands today, would not have come to fruition without the building blocks of each one of these institutions, no matter how central or limited in mandate they may be. At this point, I would like to share with you what years ago my PhD supervisor, a wise man with an exceptional legal mind, told me. If we imagine international justice as a building to be constructed, some will lay only a few bricks. Someone else will contribute 100, while others will build an entire floor. In the end, though, the building will not be constructed only by those who built the entire floor, but by concerted joint efforts of all. This metaphor sends the message that the contributions of all those committed to justice must be acknowledged, valued, and encouraged. Moreover, we are all members of the same family. The success or setback of any of our institutions affects international justice and the perception thereof. Therefore, courts and tribunals must learn from and listen to each other with open minds. Importantly, Courts should also be supportive of each other, in particular in times when we have to meet the exigencies of difficult periods. If one of us fails, we all fail. Eventually, justice fails. We should not forget the warning of Immanuel Kant, who said, if justice perishes, human life on earth has lost its meaning. The first courts and tribunals were tasked to blaze the trail of international justice, and they deserve our honor and appreciation. However, the field is not static, it evolves. We must continually seek ways to improve in order to grow, not only in terms of efficiency, but also legitimacy. Court should analyze the criticism leveled at previous such institutions, drawing on best practices and developing innovative approaches to ensure that justice is done in the most efficient and effective manner while upholding the core principles of independence, impartiality, and fairness. For example, the drafters of the Kosovo Specialist Chambers, legal framework, and the judges of our institution have sought to benefit from the experiences and lessons learned of courts that preceded our court. With some of its innovative concepts, the KSC could also make its humble contribution to the field of international justice. I will refer only to some of the novel approaches, such as the new system for the selection of judges, the assignment of judges to perform judicial duties, enhancing the role of the single judge to ensure the efficient conduct of proceedings, strict timelines, however applicable not only to the parties but also to judges, more specifically on the duration of the pretrial proceedings and the issuance of trial judgments. The management of proceedings is meticulously regulated as a central duty of judges with an eye towards efficiency. We are all aware that courts are in the limelight and are all subject to scrutiny, and rightly so. We must uphold the highest standards in the delivery of justice. We should, however, not be quixotic. Some reflections on our performance are positive. Others are critical. At times, they could be antagonistic or distortive, with the aim to create an untruthful picture of our performance, to diminish the respect for the values we symbolize, to subjugate or to abolish us. We should not be taken away by compliments, for we risk to lose the sharpness of our judicial scrutiny and conscience. We should also not disparage the critic. Particular attention should be given to constructive feedback without succumbing to speculative allegations or even threats, as the case at times may be. We should remain calm but strong. In such circumstances, we should think of Shakespeare, whose words are telling at all times: be just and fear not. The ICC, like other courts and tribunals, has faced scrutiny and critique over the years. The ICC has taken seriously the concerns expressed and has embarked on a variety of decisive steps to improve concrete areas and to demonstrate that it remains adamant in the pursuit of justice and a staunch pillar in the fight against impunity. The new prosecutor, too, has taken concrete action to address concerns directed at his office. Recently, he closed some preliminary examinations which were pending for many years and concluded bilateral monitoring agreements with these states, thereby continuing to follow the situation and providing assistance to domestic investigations and prosecutions. In March, the ICC appointed its full-time focal point for gender equality, a very important undertaking. The ICC is without any doubt unique in the field of international law. It is the one court with a global focus and broadest mandate. It is the world's preeminent standing court to respond to current and emerging conflicts or crises, which stands as a bulwark against impunity. As a former ICC judge, and having witnessed firsthand the commitment and passion of professionals working here, I'm confident that the ICC will continue to grow and will come out all the stronger as the one permanent global court. That being said, the criticism leveled, including at the ICC, cannot be laid solely at the feet of courts and tribunals. While there is a lot we can and should do to improve efficiency of proceedings and the management of our resources, states should equally take responsibility by supporting us both practically and symbolically. Being entirely independent and impartial, our courts still rely on states' cooperation, which we need due to our specific nature, limited resources and capacity, as well as lack of police force to assist in effectively carrying out our mandates. Therefore, the responsiveness and engagement of states is crucial for us to fulfill our mandates and to fortify the foundations of international justice. We expect states to speak with one voice in condemning those who refuse to cooperate with courts, or worse, who actively act to weaken us, to imperil our operation or even our existence. It should be clear that such attempts will not abate, and states have an important role in this regard by strongly voicing that there will be no tolerance for those who seek to shelter or avoid holding accountable individuals accused of having committed the most egregious international crimes. The success of courts and tribunals depends also importantly on judges. Indeed, as judges, we have a tremendous responsibility to ensure the independence and impartiality, as well as the efficiency and fairness of proceedings. The postulate of Aristotle is well known and often resorted to when it comes to law. Law is reason without passion. However, applying the law in our daily work requires passion, so that we commit to our duties assiduously and with full devotion, constant enrichment of knowledge and experience, and sacrifice of personal comfort. We judges must also abide by the high standards of judicial ethics, both inside and outside the courtroom. Accountability does not extend only to those who appear before the bench. Judges are expected to act with dignity and integrity and with respect to everyone. The expectations of and constraints for judges are highest, and the judgment of society will be merciless if judges do not adhere to the standards of the office they hold. I would like to conclude sharing again with you the experience I had some years ago in a chilly December afternoon at the Speaker's Corner in Hyde Park. I happened to be the only audience to a sermon of an elderly Asian monk who, amongst other topics, shared what his mother told him in his youth. If one day you do not have a challenge, you should notice this. If the second day you do not have a challenge, you should start worrying. If on the third day you still do not have any challenges, then you must kneel and pray passionately to God to send you challenges, because only by overcoming challenges can we become stronger. I don't remember the rest of the monk's words, but his mother's advice made me think of the field we're all so ardent about, the field of justice. We should not be discouraged or be fearful of challenges. They are invariable part of this field. And indeed, when overcoming them, we become stronger. Even the most brutal threats will not bend our will to fulfill the mission entrusted to us. We should face challenges with the full force of our collective experience, our joint wisdom, tremendous commitment, and hard work. Our success, no matter the challenges we may face, serves as a stark warning to all those who may contemplate committing such crimes, that they will be held accountable and that justice will prevail. I end by extending to all of you my warmest wishes for good health, continuous wisdom, and fortitude for the judicial year ahead. Thank you.
Dear President Trendafilova, thank you very much for your truly inspiring speech. Your words are a powerful reminder of why we do what we do in the service of international law, justice, and the protection of human dignity. Thank you again for accepting the invitation to address us today.